This is case number 21-144-120. This is Anderson Medical Supplies versus City of Detroit. The matter is set on for a review on today's date. Your appearance for Anderson Medical, please. Do I have City of Detroit on this matter?
Yes, Your Honor. Heather Powers on behalf of the defendant, City of Detroit.
All right, your P number, if you will, Ms. Powers.
P84510.
Thank you. All right, and good morning to you. So I don't see the plaintiff on this matter. Tell me what's going on, update me, give me some information.
I actually did try to contact him right before this and got their voicemail. Happy to try calling him again. But in the meantime, we have gone to case evaluation for post-case eval. Defendant did accept the award of $2,500, plaintiff rejected. Currently, they have demand of $7,000. I have countered with $5,000. So we are not far apart. I am asking that we do set this for a pre-trial date, but for that date to be after Mr. Winter's own trial. He has filed his own case. That's going to be for the 27th of this month.
All right, so he's set on in another matter for the 27th in the month of June. And so you're asking that I set this over maybe 30 days or so to take a look at what's going on at that time.
Yes, Your Honor.
All right, counsel, that makes sense. And I'm glad that you've been in contact, so you were able to update me regarding this matter. All right, so I'm going to go ahead and set it over. We'll put it in the month of July. I'm going to bring this back on July the 6th. It's going to be 7/6/22, and that's going to be at 9:45 a.m. 7/6/22 at 9:45.
Okay, and Your Honor, in case I'm just having any Zoom issues, I just want to be clear. I didn't get a hold of plaintiff's counsel, but that Winters matter, that's his own lawsuit.
I didn't hear the last part for some reason. You said you did get a hold of plaintiff's counsel, and you said something about his own lawsuit. Say that again.
I'm sorry, I'm having some technical difficulties. I did not get a hold of plaintiff's counsel for this file. Mr. Winters, the claimant in this matter, has his own lawsuit in Wayne County Circuit Court that is scheduled for trial on the 27th.
Got it. Got it. Very, very well. And so I'm going to go ahead and set this over. We should have a better insight as to what is happening with this case by that date. And I know that there have been some negotiations in terms of trying to get this case resolved. And so we'll be able to get to the bottom of that at that time as well. All right. So I am adjourning it. I'm going to set it for a pre-trial conference date, and that date is as I previously indicated.
Thank you, Your Honor. Would you like me to submit an order?
No, you'll get a document from the court. You'll get a notice from the court regarding the date, as will the other side.
Wonderful. Thank you, Your Honor.
Okay.
So, all right, this is case number 0314531-9. This is People Driven Credit Union versus Marcellus Travers. And the matter is before the court on objections to a writ of garnishment. The record in this matter should reflect that a judgment was initially entered in this matter on the 20th of March of 2004. The judgment was $20,329.29. Subsequent to that time, the judgment was renewed. That renewal date was March 18th of 2014 for $20,329.29. The garnishment is an attempt to collect on that judgment that has been outstanding. I have received the objections to the writ of garnishment. I also have a garnishee disclosure document from Alfred Benish and Company. All right, your appearance for people driven, please. Do I have someone from Mr. Holzman office on this matter? All right, I'm looking for Marcellus Travers. At this time, if you're on the Zoom, please say something. I'm not getting anyone. If there's anyone present on the matter of people driven credit union versus Marcellus Travers, please say something at this time. All right, we'll come back on the end of the call and check on that one. All right, at this time, the court calls case number 11-10-7602. This is DLG and Associates Incorporated versus Sheena Robinson. The matter is before the court on the following objections to a writ of garnishment. The record should reflect in this matter that there was a judgment that was entered. Just one moment here. That judgment. That judgment was entered by default in October the 18th of 2011. It looks further like that judgment was renewed August 17th of 2021. And the judgment balance is as of that day was $2,769.78. The writ of garnishment is as to Macy's Retail Holdings LLC. Your appearance for DLG Associates, please. DLG Associates, if you're on the Zoom, say something at this time. All right, I'm looking now for Sheena Robinson. If you're on the Zoom, say something at this time, please.
Yes, Your Honor, I'm here.
All right, what is your name, ma'am?
Sheena Robinson.
All right, thank you, Ms. Robinson. Ms. Robinson, I've raised your objections to the writ of garnishment. You indicate I was not subpoenaed and information is false, never had a Capital One or Chase MasterCard. This part of the case deals with the garnishment that relates to a judgment that has been entered for some time now. If you believe that the underlying judgment should not be entered against you, you do have the right to file appropriate paperwork to try and get that judgment set aside. That judgment is in place at this time, and that is the reason why there is the writ of garnishment. That's based on the judgment. You can object to the underlying judgment in a post-judgment proceedings. This is a post-judgment proceeding, meaning that it is after the judgment is already entered. You have to go back and try to file the appropriate paperwork to try and get that judgment set aside if you believe that it was improperly entered. And you can't do that today. Right? You understand what I'm saying to you, Ms. Robinson?
I do want to object because, like I said, I've never had.
Now, in that the
Hello.
Just one.
Hello.
Yeah, good morning.
Ms. Robinson, I'm listening to you now. You already filed your objection.
I can't hear anything at all.
Judge Coleman.
Ma'am, I keep getting interrupted by other people. I hear you loud and clear. Just hold on a second. Let me clear out some other people that are interrupted. Just one moment, thank you. Mr. Travers, I called your case previously. You didn't respond. I'll come back to it. So stay on mute now because you're interrupting other hearings. Stay on mute until I come back to your case. Thank you. All right, Ms. Robinson, you already filed an objection to the garnishment, and that objection doesn't mean anything now because what you're objecting to is the underlying judgment, not the garnishment. You don't have a garnishment objection. That's why the categories, as you remember when you filled out that form, again, there are a number of categories, A through F, and the category that you picked was F. It says the writ has not been properly issued, otherwise is invalid. Well, no, there's a judgment in place. That's why the writ is issued. If you believe the judgment should be in place, that's the appropriate paperwork to try and get that judgment set aside.
And see, I was unfamiliar with this because this is I don't fill out paperwork like this. So the guy just was underlining things and I should have read it. I do apologize for that. But yeah, it's like
No apologies. No apologies, ma'am. This is not something that I'm saying that you did something wrong and so on and so forth. That's not what I'm saying. I'm saying procedurally, you have to approach it differently because the post-judgment and pre-judgment is treated differently. And there's a court rule that does not allow me to inquire into the pre-judgment issues when it comes to the post-judgment document. Post-judgment means after the judgment has already been entered. And there's a garnishment that's been brought against you based upon that judgment. You're attacking the underlying judgment, and you can't do that in a garnishment proceeding. So what you have to do, I can't give you legal advice, but just a little bit of information. If you believe that there's some reason that that judgment should be set aside, number one, you're kind of late on that because this judgment has been in place for a long, long time. And there have been documents filed over a significant period of time.
I've never received those documents, Your Honor.
Sounds like you're interrupting. It really does. It really does sound like you're interrupting. That's probably not the wisest thing to do when I'm talking, because I always give you opportunity to talk. That's probably not the wisest thing to do, to object when I'm talking, when I'm explaining something to you. But in any event, if you want to, I apologize for that interruption. All right, if you want to file something in the nature of a motion to set aside the underlying judgment that was entered in this matter, then you certainly have the right to do that. And when you do that, I will view those issues that you bring before the court and make a decision as to what the outcome of this case is. And again, one of the key issues here is going to be that this case got started, just to give you information here, this case got started back in 2013, it looks like. Let me go further, make sure. Actually, sooner than that time, 2000, looks like 2011 is when this case initially came before the court. And then there have been a number of things that have occurred since that time. Subpoenas were issued, et cetera, et cetera, et cetera. So in any event, ma'am, one moment. Yeah, it's been going on since 2011. So as it relates to the objection to the writ of garnishment, you don't have a valid objection at this time. Now, is this the place where you work? Where this garnishment was filed, is this involved your workplace, ma'am?
Yes.
All right. So has any money been taken from you?
$944 has been taken. I have all the check stubs.
Okay, and so how did you get to that amount? How much is taken from you weekly or bi-weekly? How will they do that? How much is taken out when you get your pay? Do you get paid bi-weekly or bi-monthly or weekly, or which way do you get paid?
I get paid weekly and they take whatever they choose to take. Sometimes it's 98, sometimes it's 102, sometimes it's 128, sometimes it's 130.
Okay, got it. So it's really not a matter of what they choose to take. The law allows for 25% of the portion that would rightfully be entitled to you. And so whatever that number is that they're taking is based upon the calculation of 25%. So your 25% rate, if you will, the lowest amount has been 100 and what? Now, I'll need you to look through all of that, ma'am.
The lowest amount has been 102.
102, and the highest amount has been how much, ma'am?
128.
128?
Mm-hmm.
Is that what you said?
Yes.
All right. Very
Yes.
well. All right, so, okay, gotcha. All right, so what I'm going to do, Ms. Robinson, is I'm going to put a partial payment order in place and give you the opportunity to file whatever you wish to file. This will at least take the while you're doing
Thank
the. Now, Mr. Terry, I told you that you're interfering with the hearing. You keep coming in before I call your case. If you come back in again before I get back to your case, I'm gonna hang up on you. You won't be able to have anything heard about your case. Every time you come off from you're interfering with other hearings. I'm in the middle of a hearing now. I know that it's not that difficult to understand me saying that. I've said that 2 or 3 times now. Don't come off from mute until I call your case. Thank you. So, ma'am, rather than the $400 or so that are being taken out of your check at this time, what I'll do is I'll allow you to make the voluntary payment at $100 per month. And then if you're successful on your motion, then the money that's been taken from you, as well as the monthly payment, will be set aside because you got the judgment set aside. But right now, that judgment is in place. So what's going to happen today, ma'am, is I will find that the objections are invalid. The funds will, at this time, be released to the plaintiff. I'll stop the withholding. So there, I will stop the withholding, ma'am, and then I'm going to set up a partial payment plan for you. And that partial payment plan is going to require that you pay $100 on the 17th of June, and then each month on the 17th until you get this worked out or until the balance is paid. That way you don't have the garnishment in place, but you have the $100 payment. Again, if you're able to get all of that, if you're able to get that judgment set aside, then any money that has been collected from you would have to be refunded to you. But if for some reason it's not set aside, all of the money that you've paid is going towards paying off the judgment. And then the second thing that you can accomplish is that you don't have a garnishment against your wages. So you'll get an order from me stopping the garnishment, but you will have to make that monthly payment on the on basically the 3rd Friday of each month, and you would make that payment directly to the attorney's office. The information is on the forms that you receive. You make that payment in the name of VLG and Associates, and you send it to the attorney's office. And then again, when you file your motion to set it aside or whatever, the court will take a look at that. If you win on that, you get all your money back and you start at the beginning or whatever the issues are at that time. You understand what happened today, ma'am?
Yes.
Any questions before I have to move on? Go ahead, ma'am.
Okay, so from now on, my wages will stop being garnished, but it will be $100 a month until I take the proper proceedings and go and file another motion to cease it, correct?
Yeah, and don't think that you're just filing another motion. You understand, and I'm taking a little bit of time, and I do have other cases, because you have to understand that you're dealing with pre-judgment, post-judgment. There's a judgment against you. That judgment against you gives the other side the right to collect money. That's why you have the garnishment. Today, I'm stopping the garnishment to allow you to go through whatever process you want to go through to try and deal with the underlying issue. That's something totally different. If you get that underlying judgment set aside, then you're entitled to your money back, et cetera, and that may very well be the end of the case. If not, then you at least do not have a garnishment against your wages. Then you have the right to pay at $100 a month, and that will keep the garnishment up off of your employment. So procedurally, that's how you got to go forward. Of course, you file your motion regarding the pre-judgment stuff to try and get that judgment set aside. I'll take a look at it and see what you are saying in that regard. And if you win it, you win it. If you don't win it, at least you got it set up where you can get this taken care of. Okay. Any other questions before I go on that?
No, thank you, Your Honor.
All right. And when you get you'll get the order of the objection from me, and you'll stop the garnishment. You'll want to take that to your payroll department, and that will show them that they can stop the garnishment. And then you'll also receive an order from me. It's called a partial payment order. That's the thing that will keep the garnishment up off. You understand?
Yes, I do. Thank you.
I wish you well, man. Pardon all of the interruptions this morning. Everybody started chiming in as soon as you started getting on with your case. And of course, that get kind of irritating to me as well. Some kind of way. All right, I wish you well, ma'am. You receive
Thank you,
documents.
Your Honor.
Keep the day to you.
Oh, okay, leave.
All right, I previously called people-driven credit versus Marcellus Travers. That's case number 03145319. The matter is before the court on objections to a writ garnishment in this matter. Do I have, first of all, people-driven credit union? People-driven credit union. Anybody from people-driven credit union? All right, do I have Mr. Travers on this Zoom? Say something if you hear.
Yes, yes, I'm present.
All right, thank you, sir. I went over the last time I called this case that this was a judgment entered back in 2003. It was renewed in 2000, looks like 2013, starting at 2014. This is a $20,000 judgment, and that's why there is collection efforts against you. You work for Alfred Benish, is that the place that you work for, sir?
Alfred Benish, yes.
All right, thank you. All right, and I've noted your objections. You filed indicating that you have an installment order in place. And then you said the writ is not properly issued, otherwise it's invalid. And you asked me to look at addendum number 1. And just one moment here. All right, so you pretty much are saying in the addendum that this is not the proper person and so on and so forth. Those are underlying issues. If you feel that you have a basis to attack the entry of the judgment after these years, you can certainly file a motion to set aside the default judgment in that regard. But on the issue of there being a partial payment order in place, what partial payment order? I'm looking, I don't see where there was one issue, but this is my first time taking a look at this. Tell me about that.
Yes, there was a partial payment put in place about a month ago, about 4 weeks ago, because I have been garnished on 2 checks since then. I get paid bi-weekly, and it's just.
I always say bi-weekly, but I think you mean bi-monthly, right?
Yes, bi-monthly. I'm sorry, 2 times a month, every 2 weeks.
That's what I've been doing this for years, and every time I'm by this Saturday, I say bi-weekly. I don't know about bi-weekly one.
Bi-weekly, every 2 weeks. So this is
Paid twice. I know what you mean. You mean twice a month. Let me see if I can find it, because I'm not seeing how much was the partial payment order. A lot of you paid partial.
it was let me see. It says $384. Around $350. The garnishment says 384, but my check has been about 356.
Okay, but you said you had an order from the court that allowed you to pay it in increments?
I got an order from the court saying that they will be garnishing me.
Oh, okay, all right, yeah, they are garnishing you.
They are garnishing me, but the thing is, that's not me. My name is not on the garnishment. It says Marcel Travers. I've never filed or applied for a loan under that name, Marcel Travers, or that PO box. I don't know that PO box. Never used it. This supposed auto loan is from 20 years ago, and this is the first time I'm really seeing about this, and I want to do something about it. So I filed an objection under the pretense of that it's not me. That name is not me. I never filed or applied for a loan under the name of Marcel Travers, nor that address or any address that they have on here.
All right. Well, you certainly have had a judgment entered against you for years, and
Yes,
there have been garnishments as it relates to your income tax return over the years.
right. And I had no idea of that. No idea. This past 2 years is the first time I've received income tax return because of student loans. Now, in recent years, it has been revealed to me that I have been a victim of identity theft from my family, and it dates back 20 years. Now I'm just now seeing this. I have a letter from the IRS about fraud resolution case and what to do about it. I had to file a police report on stimulus checks that was stolen from me, credit cards that was put in my name. All of this has come into revelation as of 2 years ago. And this auto loan dates back 20 years ago. So this is really putting the bump on the road and moving forward. I'm trying to buy a home for the first time in my life, and it's one of my dad's home. My dad passed away. His half children, out of 6 of them, 2 of them are living. One is in an assisted living place, so they want to sell his home, and I'm in position to buy it. And all of a sudden, this comes up. Now I'm being garnished approximately $700 a month, and it's just out the blue. So I just would like to do something about it.
It will have to be your effort to try and get that judgment set aside if what you want to do. You have to file a proper motion for that. The only thing I can deal with today is to deal with the garnishment issue that you have. Because this judgment has been around for a long time.
A long time.
Yeah, it's been around for a long time, and it was renewed. There were collections against you, and et cetera, et cetera. So the only part I can deal with today is the objections. It looks like the basis that you indicate for setting aside the garnishment or objecting to the garnishment, they're not valid objections. The only thing that could have possibly been a valid objection would have been, you said you have an installment order issued by the court. I don't think that you have an installment order.
I do. It's
Can you show it to me? You got it with you?
Yes.
I don't see where I issued any order partial payments.
Yes. I have it right here.
Go ahead, tell me about that.
It says I object to the writ of garnishment issued May 3rd. I'm gonna go back and find the actual written garnishment. I think that was my objection.
Let me. I think you're talking about something different from what you put on the form, because I think you're confused. You could have come to the court and filed asking the court to give you the right to pay the judgment in increments. That's called a partial payment order. And you put on the form that you came to court and saw the partial payment form order, that the court issued a partial payment order for you to make it an installment payment. I don't think that happened. I think what you're saying is that being garnished.
Yeah, I'm being garnished. I'm being garnished. It says right here.
Listen to me. There's something very distinctive that I want to make clear, because I don't show anywhere where there is where you came to court and said, Judge, I have this judgment against me. I want to make sure.
Too much noise, Judge.
No, I don't. I never came into court.
Hold on a second.
I think that's where he is, unless it's Mr. Rusin. This is too much noise.
That's not Mr. Wilson's noise. You got some noise in the background there, Mr. Travers?
Why would-
Yes. No, I don't. That's not nobody talking around me.
Just one moment.
That's him. It's just lighting up. That's him, Judge. People, wherever he is.
Yeah, you had something going on in your background. That's confusing. But okay, so you never came to court and filed to have the right to make partial payments, right?
Correct. I never came to court.
So yeah, so that part of your motion, that part of your motion that does not provide a basis to set the garnishment aside. So I don't see a valid objection to the garnishment. If you believe that you should have the or that you have some basis to have the judgment set aside, then you could certainly file a motion to set the judgment aside and ask the court to set that judgment aside and show the reasons why you think it should be set aside. But this is dealing with garnishment.
Yeah, the reason why.
Go ahead, sir.
No, I was saying the reason why we're here today is because I filed an objection to garnishment. I faxed it over to the court, and this is the result of the hearing today of that objection to garnishment, which I filed after I got the garnishment for my job. No, I never personally came in. I faxed it over to the court.
Yeah, but you still, every time you talk, you confusing some other stuff. But see, when you filed your objections, you put on your objection that you have an installment order. You never came to court and you never filed anything asking for an installment order.
No, I never did. The attorney's office did.
Oh my goodness. Okay, so do you have a paper or something you can show me that looks anything like something like this, like an installment order that says that you have the right to pay X amount of money each month? You have that?
It's a request of writ for garnishment, periodic. No.
That's not a voluntary, that's a garnishment.
Okay.
What you put on the form is that you have a voluntary payment order, and that's confusing things because I don't think that you have a voluntary payment order.
No, I don't have a voluntary.
Okay.
What do you mean by that? Voluntary? No, I don't have a voluntary payment. Yeah.
When you put on the objection to garnishment that I have an installment payment order, that's what that tells me, that you have a voluntary installment order, and you don't have that. What you were talking about is that there is a garnishment. That's what you were talking about, right?
Yes.
Okay. Now, that's a big difference. It makes a big difference because of course there's a garnishment. That's why you would be objecting. So, but marking that box, that means something else. That means that wait a minute, they should not be able to garnish me because I'm already voluntarily paying.
No, I'm not voluntarily paying. I've been working.
That's the box that you check. That's what's confusing them. That's the box that you check. Says you're installment. Okay, I got it now. So your objections are a real basis for the objections at this time. I will give you some on the garnishment. You said that they're garnishing how much from you a month? 700?
Yes, approximately 700 a month.
And you're planning on filing some type of motion to try and get this judgment set aside. So I'll whatever funds have been taken, I'm going to release those to the plaintiff. But I will stop the garnishment. But you'll have to make voluntary payments on a monthly basis. I'm going to set that payment at $200. So your garnishment will stop. They won't take any money out of your check, but you have to voluntarily, you have to send the $200 to the office that's on the form. Make it out to People Driven Credit Union and send it to the attorney's office that's on the form. Now, you can also file a motion to get the judgment set aside. If that works, then any money that's been taken from you, get it back, and you will no longer have to make the monthly payments. The monthly
Right.
payment is designed to stop the garnishment. As long as you make that monthly payment, they can't garnish your payment.
Yeah, I thought this was the objection hearing for that.
It is the objection hearing.
Because the reason why I objected is because the auto loan is not in my name. My name isn't Marcel Travers.
Okay, well, let's stop it right there. You already told me that.
Yeah, I'm just trying to get an understanding of you said object filed.
Let me stop it. Let me stop it. You're not that slow. I've gone through that 3 or 4 times to explain that to you. So I won't explain it. So unfortunately, what I have to do at this point, I have to find that the objections are invalid. If you're gonna object to the judgment, you have to file something separately to object to the judgment. You can't do it on this.
Okay.
You don't have a valid reason to object to the garnishment. Now, what I would normally do right here is just leave the garnishment in place. That means that they keep on taking your money. Now, you plan on in the future trying to get that judgment set aside. That's what it sounds like, right?
Yes.
So how about you get some relief from what they're taking from you temporarily so that you can file the objections that you want to file? Because if I don't set you on a partial payment order, then they're going to keep taking $700 a month.
Right.
So I can set you up a $200 a month payment. As long as you're paying that, they can't take the $700.
Correct.
And way you can still file paper to try and get that judgment set aside.
Okay.
You understand
Well,
what I'm saying?
I understand.
I suspect, I mean, I know you've got plenty of money, but I suspect that $700 a month is impacting your household. So let's get that reduced to 200.
It is.
If you can get it set aside, then maybe you won't have to pay the 200. But until you can address the judgment, there's a judgment entered against you. You have to file something to say that judgment shouldn't have been, it's not me, whatever. You have to file paperwork in some type of motion to deal with that. You can't deal with that during the objections to garnishment. That's separate. So I'm going to set it up the way that I'm saying, and you'll get 2 orders from me. One will be an order stopping the garnishment. You want to take that to your payroll when you get that from me.
Okay.
Stop. Beginning in the month of June, June 24th, you have to send in a voluntary payment of $200. June 24th. As long as you do that every month before Friday, as long as you send a payment in of $200, they can't garnish your wages. And if you get it set aside, all of that will be set aside too. But right now, you still have a judgment. You understand what I'm saying to you?
Yes, I do. I have one question. Do I file this with the court or?
You file it at 2nd floor, 36th District Court. Same place you filed the other stuff.
Okay.
Right?
Okay. So,
right. So you'll
okay.
get 2 forms from me in the mail. And one you'll take to your payroll, and the other you'll use as your payment plan until you get something set aside. If you don't get anything set aside, then you just deal with the payment plan, and that will keep you from having the wage garnishment. All right.
Okay.
I wish you well, sir. You'll get some paperwork from the mail. All right. Good day to you.
All right. Good day. Thank you.
All right, this is case number 18-152-554. This is Baker College versus Rayvon, looks like Callis. Keys. All right, thank you. Rayvon Keys, matters before the court on the filing of objections to writ of garnishment, and also has attached a motion for partial payments regarding this matter. Record should reflect that a judgment was entered by default on the 31st of May of 2018 for $3,735. Your appearance at this time for the plaintiff, Baker College, please.
Yeah, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
All right, thank you, Mr. Cox. Good morning to you. I'm looking now for Rayvon Keys. If you're on the Zoom, say something at this time, sir.
Yes, I'm here.
All right, thank you, Mr. Keys. And Mr. Keys, I have taken a look at your objections to the writ of garnishment. You checked off the F box. It says, I never received a notice of the garnishment until May the 5th of 2022. Well, that would not be a basis for objecting, because these things often come by way of surprise. I mean, that's the whole the surprise element. They don't have to give you notice that you're getting ready to be garnished. But I also saw that you filed a petition asking the court to allow you to pay at $100 a month regarding this matter. You indicated some of your expenses of living as a part of the reason why you like to pay at that particular rate. Is that correct, sir?
Yes, sir.
So it looks like you indicated to me that you make $800 a week, or average of about $800 a week. Is that correct, sir?
Yes, sir.
All right. And has any money been taken from you under the garnishment? Has any money been taken out of your check so far?
Yes, sir. They were starting May 5th. They were taking $300 out of every check.
All right. So how many times has that occurred? About
4. It started at the very first week of May. So 4. Yep.
4 times?
Yes, sir.
Your Honor,
So, yeah.
I was just going to add that we've only gotten 2 of those withholdings so far. I'm not doubting that they're on their way, but we've gotten $278.86 on May the 16th and $282.07 on May the 24th. So I imagine probably then 2 additional withholdings if what Mr. Keys is representing is accurate on their way, but that's what we've gotten to date.
All right, and likely this week they're likely going to take another one this week, because there's probably nothing we can do to stop it before that time. All right, so it looks like the total, the balance on the judgment is how much at this time? What do you have as a balance, Mr. Cox?
Well, Judge, with only the 2 withholdings received to date, we show a balance of $3,614.71. But again, that's only with the approximately $550 that we've gotten for the 2 withholdings.
So, Mr. Keys, it looks like you're probably going to have 3 other the 2 they received 2 of them. So 2 other ones are floating in the air, and then they're probably going to take one this week. So that'll bring your balance. If all those things to be true, that'll bring your balance under $3,000. Mr. Cox, what are your thoughts regarding the $100 a month request?
Well, I would say this, Judge, we did get the objections to garnishment. I don't see that my office received or at least processed the petition for installment payments. That being said, by my math, if he's getting paid weekly, and the disclosure said payments or withholding being done weekly. So if I'm to believe that the $280 is coming out per week, that's $1,260 a month if the garnishment's left in place. Plaintiff thinks that maybe something closer to $200 might be appropriate, given the amount that's already coming out. Now that sort of dismisses his issues with regarding to finances. My suggestion would be maybe push the first payment due date to July, but make it $200. That's what I would suggest.
Yeah, there's a lot of money being taken out of your check, and you're right that I think, given the judgment that's coming near to about $3,000 balance, you shouldn't have to pay $500 a month to try to resolve that and all that kind of stuff. But the 100 seems kind of low. So what I'm going to do, Mr. Keys, I'll find that the objections as raised are not valid. I'll release whatever funds have been withheld to the plaintiff, and then I'll stop the garnishment. And I'm going to allow you to make partial payments, and I'll go ahead and begin that in July the 1st. And I'll set that payment at $200 a month. I think that's a reasonable amount to set, and then that will stop that'll stop garnishment. I'm going to get out to you right away the stopping of the garnishment, the suspending of the garnishment. You want to take that to your employer so that they can know to stop taking money out. You'll have to make the voluntary payments beginning in the month of July. You make one payment a month of $200, and there should be no garnishment against you in that regard. You understand that,
Okay.
sir?
Yes, sir.
All right, so I'm going to get this paperwork out to you in the mail today. Of course, counsel, you'll get the paperwork as well. And I wish you well, Mr. Keys. Thank you, counsel. Good day to both of you.
Judge, just one other
Thanks.
thing. If Mr. Keys can mail a check or money order payable to Baker College to my office, to the address that's on any of the paperwork he's received to date, or he can call my office at the number listed.
Mr. Cox, let me just put you guys together for just a moment.
Perfect.
Mr. Keys, I'm going to send you a notice so you can talk about logistics about how you do that. So just click into the breakout room.
Okay.
And exactly.
Thank you,
what
Judge.
you need. You're welcome. All right. Good day, Judge.
Thank you, Your Honor.
All right, this is case number 21151. 911. This is Aspercare's Pharmacy versus Homeowners Insurance. Your appearance for the plaintiff regarding this matter.
Good morning, Doug Harris-Kevich on behalf of the plaintiff, 81458.
Thank you. Good morning to you, sir. And for the defendant in this matter, your appearance, please.
Good morning, Your Honor. Jalise DiBiase on behalf of defendant auto owners, P number 79916.
All right, and I know that that something about this case is on appeal, and I set this as a control date. So somebody go ahead and update, please.
Yes, Your Honor, when we last spoke, our application for leave to appeal was assigned to Judge Sullivan in Wayne County. Since that time, we have completed briefing on the appeal. Plaintiff filed a response. We filed a reply in April. So the briefing portion is done. However, we haven't seen anything come through the court yet regarding whether they intend to schedule oral argument on the application. So that's what we're waiting for at this point.
It's interesting. All right. So what do you think? Put it out 60 days and review it.
That sounds good.
That sounds good, Your Honor.
All right, so we'll calendar it for 60 days or so. The next action date in this matter is going to be, I think that's puts us in
August.
August.
No, August 4th.
Yes, August 4th. August 4th, 10 o'clock a.m.
Okay. August 4th at 10?
That's correct. And we'll
Okay.
generate new notices in that regard too. And again, it'll be set up for a review.
Okay,
Hopefully they'll get to a decision as quick as I got to.
hopefully.
All right, all the
Six
best.
one year. You got 5/19, 6/1. On the date.
Yeah,
Order.
no.
Oh.
That should be today.
Okay, all right.
Must have started.
Yeah, I think you were looking at this around that date. That was the motion, the actual case.
Yeah. All right, so we'll get that information, that new date out. To you. All right, we were talking about something else, so you guys are all set. All the best to you.
Okay, thank you, Judge. Have a good day.
Likewise. All right, case number 21-170-980. This is Credit Acceptance Corporation versus Kristen Smith. That is before the court on the filing of objections to a writ of garnishment. This matter relates to the entry of a judgment on March the 28th, 2022. That judgment was entered by default for a total sum of $20,397.47. All right, it's been a good morning, and your appearance at this time, counsel.
Judge, may I please court? I'm attorney Richard Russo. I'm an attorney of record for the plaintiff. I'm also the respondent to defendant's objection to a wage garnishment today.
All right, thank you, counsel, and good morning to you, sir.
Hi.
Kristen Smith, good morning to you, Mr. Smith.
Good morning.
All right, sir. Yeah, I see that you filed objection. You indicated it wasn't delivered directly to me personally. So that would not seem to be a valid objection. Are you saying that a garnishment was not delivered to you personally? Is that what you're saying?
I didn't know about the garnishment until my job mailed me the writ of garnishment. And when I took it to the courthouse, or when I called, the lady at the courthouse was just saying, relay the message that the officer or whoever delivered they didn't deliver it to me personally. So that's the only thing that I set the court date for, just to acknowledge that. And just to see what I can do, because this is for my brother's car or something I co-signed on. So I'm just trying to get that out the way. I just can't have my checks garnished right now. I'm in a kind of a hard point in my life right now. I'm trying to work and take care of my kids. So I'm just trying to see what I can do.
All right. So yeah, I do have. So they wouldn't have had to serve the garnishment, garnishment on you, but I think you're referring to the complaint that was filed in the case. And I do have an affidavit from a process server that says that he served you with the process on the 20th of January this year. It says that he served you at the Roselawn address, 8278 Roselawn. So that's how the judgment got in place. It was entered by default. What the file says is that they served you, and then you didn't file any answer or response or anything. And that's how judgment got in place.
8278. I'm sorry, Judge. 8278 is my baby mama's house. Me and her wasn't at a good standing at the time. Is my daughter's where they live. I wasn't there, at the time, and I wasn't there for about a month or two, depending on when they said that it was dropped off. She didn't let me know anything, so that's why I was like, "Hey, what's going on?"
Wait, on the score it says black male 30, 5'10", about 200 pounds of dark hair. So how old are you?
I'm 26. My brother, they probably served my brother directly. They didn't serve Christian Smith directly. DeMarco Everett, that's my brother. They probably served him, but that had nothing, to do with me. I haven't talked to him about it. He ain't informed me or told me he was moving on it or anything. I'm just like, hey, where is all this coming from? This is because I had a 2013 Malibu that was in my name that nobody co-signed for. and I co-signed for his car. So I'm guessing they're trying to come after both of us because I co-signed, right?
Absolutely. When you co-sign it, you're as equally responsible as the person that is the principal signer. It's really no different. In law, it's no difference.
Okay.
You're just as responsible as he is. That's the challenge.
Okay.
All right, so you certainly have the right, if you believe that you want to do that, to file a motion regarding the issue of you not being served. You can't raise that in the hearing on the objections to the garnishment. The garnishment and the judgment is separate. The judgment was entered in this case on the basis that they claimed that they served you and then you didn't answer within a certain period of time, and so the judgment got in. If you believe that something went wrong in that process, you have the right to file a motion to try to get that set aside, to try to get that judgment undone. But as long as that judgment is in place, the plaintiff has the right to pursue collection on that judgment. And that's what the garnishment is about, is collecting on the judgment. So you may want to file something attacking the judgment itself. But right now we deal with the garnishment, and I don't see the issue that you raised here. It cannot really be properly raised in this hearing as far as you didn't get served in the underlying case, and therefore you shouldn't be able to get garnished in this case. The law doesn't allow you to do it that way. How much money?
And Judge, that's fine. I'm not tripping about that. Because I already know it's been passed. Like I said, if it came to my job and mailed to my house, then it's in effect, and they're going to start taking money. I just, as far as the 25%, like I said, I'm going through trying to, handle my business by myself. I'm only doing things myself. Trying to take care of my kids. The 25% just seems like a lot. If I could try to cut it down just a little bit, I can make those payments. I already tried to file for bankruptcy too. So I just want to see, what can I do to go forward.
Gotcha. And how much has any money been taken out of your check so far?
I haven't noticed. I mean, it was one check that seemed like it got touched, but when I checked my ADP, it didn't say like a garnishment. It just said like life insurance or some other. I don't know. I don't know yet. I really don't know yet.
All right. So how much do you typically bring home a week? Or you get paid every week or every other week?
I get paid every week.
Every week. How much you typically?
I bring home every week. I make $700.
Okay. And you pay a mortgage or rent or something somewhere, correct?
Right now I've just been like really living with friends. Recently I just moved back with my parents, and they just want like $300, from me for just staying there. So.
All right. So what else are you paying?
I have a car note right now. I have to pay for my stepdaughter's schooling. And whatever, diapers and wipes for my biological kid that I just had. She's one. Just diapers, wipes, and clothes for her. Phone bill. That's pretty much it.
Yeah, gas and other expenses, right? How much is your car note, sir?
My car note is $456 a month.
All right, Mr. Rosen, anything, sir?
Judge, I will tell you that I have not heard on the record so far what Mr. Smith purports is proposing to pay per month based on the background of his income stream and his normal weekly expenses. Is there a dollar amount he wants to put on the record?
What are you asking to be able to voluntarily pay per month, sir?
I could do 120 a month.
All right. I can tell you, Judge, two things. I can tell you that the statutory interest on this judgment is 13%. And when I calculated that statutory 13% interest on the judgment balance today, I came up to a monthly interest amount of $233. So the second thing I will say is that I will stipulate to an installment payment order of $120 per month. Perhaps that can begin 30 days from now, on or about July the 1. depending on what Mr. Smith's predilections are. I would also close my argument by suggesting on the record to Mr. Smith that he should stay in contact with our office. He can call anytime between 8:30 and 7 o'clock at night, talk to somebody at my office to see if the case can otherwise be settled, but I'll leave that for the future with Mr. Smith.
That's cool. Thank you.
Yeah, the big challenge that you have, and thank you, Mr. Rosen. The big challenge that you have here, of course, is that you co-sign on a situation that ends up being a large amount, and a lot of the cases here, are in the $2,000, $3,000 range. But you just so happen to have one of these situations where there's a $20,000 judgment, and then it's still accruing interest and so on and so forth. So you may in the future want to talk about ways that maybe you can get that resolved realistically, because at $120 a month,
I'm gonna be paying that forever, and I understand it. That's why, like I said, I already tried to file a motion with going bankrupt. If I have to deal with that, then I have to do that. But I at least wanted to talk to you guys, see if I can, pay something just towards it and just try to get this handled.
All right, well, what I find is, first of all, the objections, there's nothing valid about the objections, so I deny the objections to the writ of garnishment, and I'll release any funds to the plaintiff that are withheld. Then I'll stop or suspend the garnishment, and I'll allow for a partial payment. So I'm going to set up a partial payment at $120 a month, and I'll commence that on July the 1st. So you have to make your voluntary payments commencing July the 1st, 2022, and that payment will be $120 per month. The garnishment will be suspended as long as you make that payment. If you don't make the monthly payment, then the garnishment will be reinstated, which of course causes other kind of problems, as you know. All right, and so you'll get 2 orders from me. One is an order suspending the garnishment, and another is an order for partial payments. I do wish you well going forward. Again, keep in touch with Mr. Rosen's office if you have a strategy for trying to tackle this in some other ways. They certainly will be open to that. If you come into a lump sum or something, maybe you can discuss a way to pay it off and be done with it. Any of those kind of things, you at least want to run those by his office to see if that's something that they would be interested in terms of resolving. Otherwise, I do wish you well, Mr. Smith. Thank you, Mr. Wilson. Good day to the two of you.
Thank you, one and all.
Thank you. Y'all have a good day.